And here is the faculty member and student. So introduce and Dr. Manjit Kaur. Okay, it's a dedicated and experienced academician with zeal for research and providing quality education. Currently, she is working an associate professor at Business School and Chandigarh University. She is Innovation Ambassador with Ministry of Education, a PhD Management from IK Gujarat Punjab Technical University, and having more than decade experience in higher education sector. She has a good researcher record with 28 research papers published in reputed international and national journals and keen interested in entrepreneurship development and innovation. She has presented more than 20 research papers in international and national conferences, seminars, and has two books to her credits as well. She is editorial board member and reviewer many reputed journals, including ABDC Indexes journals, has acted resource person in many seminars and works. So, ma'am, very intelligent person, and so thank you, ma'am, to give your time, and also received International Research Award 2021 by International Institute of Organized Researcher. Thank you, ma'am.
Thank you, Sanchita ma'am. Thank you so much.
Welcome, ma'am.
Thank you, ma'am. So, should I start the session or you're waiting for a little?
Yes, ma'am. Yes, ma'am.
Okay, thank you so much. Thank you, Sanchita ma'am, for putting good words for me. And first of all, before starting, I would like to thank Mr. Abhinandan Sarkar for inviting me, and to management of Shri Ramakrishna Institute of Science and Technology for inviting me for this session and to interact with all of you. So today's session, it is all about IPR for academics, right? So as we know, IPR has taken a special, it has taken central role in academics, especially with the UGC, with UGC coming up with new regulations when UGC approved national IPR policy, and it was approved by the Union Cabinet in May 2016. And it was the first ever IPR policy framed by the Government of India. So the main purpose of framing this policy was to promote innovation in the country, innovation in the education sector. So the main focus is IPR in academics. It means IPR for both faculty as well as for students. So there is now a lot of research is also going on related to intellectual property, and now I hope faculty members present here, they must be aware that now for our promotion also when we have some patents, we're doing some innovations, we get we get score for this, and in our increment also it's very helpful. And of course our CV, our resume, it gets more strong the more patents we have. So that is why this session is important. So just give me 1 minute. I will be sharing one PPT with you. Then I will. So I just want to discuss how we can go ahead with IPR. Basically, what is IPR? So that will be discussed. So I'm sharing PPT. I hope it will be. Just give me 1 minute. Okay. I hope it is visible.
Yes, ma'am. It's visible.
Okay, good. So, what is basic? If we have to define, everyone is talking about IPR. IPR. What is basically IPR? IPR is basically intellectual property right, and IPR, it is the way if we have some property. For example, I go outside and I buy a car. I pay for this. So that is my property, right? And I have right on this. Or for example, A painter, paints a new painting. So it is the creation of a painter. So painter has right to that painting. So that is creation. That is creation of his mind. So that is his intellectual property in simple terms. So now, if we define intellectual property right in legal terms, it can be defined as the legal right which result from intellectual activity in the industrial, scientific, literary, and artistic fields. And if normally, if we define intellectual property right, what is it? It is a property that arises from the human intellect. The property that is formed, that is arise from our intelligence, from our creativity. That is basically intellectual property. And it is a creation of human. It's a product of human creation. And basically, when we speak about intellectual property, it is basically it can be defined into two basic forms. One is literary and artistic work. The way I give you one example of painter painting. So that is a very good example of a literary or artistic work. And then we have this other is industrial property. Industrial property means if some new design, some new product, some new idea that can be used for business purpose or for creating a new product, that comes under industrial property. Okay, so now let's discuss intellectual property. Intellectual property, it's a creation of our mind. That is why we call it as intellectual property. So intellectual property, it is a property. Why? Because it can be sold, it can be bought, it can be lease or rent, it can be assigned, it can pass under a will. If a person comes up with some new idea or some new, for example, design of a new innovative product, so that's a design, that's an innovation. So the same design, a person, inventor, he can sell to any company, any industry who wants to convert it into real product, or he can keep it to himself. He can have the rights for this, and whenever if he or she himself wants to start his own business, he can use that. Or the same person can give that design to some company for making products for some years, for example, for 10 years. He can give rights for 10 years and lease or rent it for 10 years. So that is why these type of properties in these designs or these ideas for business, these are regarded as property because they can be sold, they can be bought, they can be leased or rent, and they can be assigned, and they can pass under a will. Now, what is role of intellectual property? Role of intellectual property is basically because it is creation of a person who has used his intellect for creating some new ideas, some new plans, some new design, or for example, in case of artists, they have got some new painting or some any other artistic thing. So, but it is economic right of creator. The one who has created that, it is his economic right, in the sense that he is the one who has to be benefited if the same if the product or any product that is created by using that designer idea, if it is sold, the economic rights, the money that is for creator, the right, economic right lies with the creator. And again, commercial exploitation, if the person, if he is coming up with some new innovative idea which can be commercialized. For example, there is the idea of having this, for example, oyo rooms. Oyo rooms, he did not own anything, the hotels, or they were not his, right? The founder of Oyo. But what he did, it was his idea, his unique and innovative idea, that he will only help those hotels or which are not doing good. He helped them by filling their rooms in off season by putting it on his website, right? So that was something innovative. So his innovative idea he has used, so he has the right to use it for commercial exploitation, to use it commercially for business purpose. And another point is that intellectual property is a capital expenditure. Capital expenditure means it is something with whose benefit a person can get for a long period of time. So capital expenditure is that type of expenditure whose benefit we are going to get for a long period of time. And intellectual property is something, that idea, that new innovation, its benefit one can get from a long period of time, right? And intellectual property, it also involves transfer of technology. If an innovator, if a creator comes up with some new idea and he wants to sell his idea, so that is basically transfer of technology. Okay? And it is cultural development. Cultural development, it means with new innovations, new ideas, some new, the people when they come up with some new ideas, innovations, and it is development of the nation as a whole, development of a culture. Like other people, they will also get motivated. They will also try to do something new if one person is successful. And one important question arises: why IP protection is needed? Why we want to have our patents registered? Why there is need for intellectual property protection? Why? Because with intellectual property, profit is involved. We can convert it into some good business proposal, good business, and we can earn profit, right? So that is why it is important to protect it. And another important is that it is important to maintain loyal followers. For example, if one person is coming up with some great idea, some innovative idea, so he has some innovative idea and he comes up with some business with that innovative idea. So his business is making profit. But what if others copy the same business model? Then there is no uniqueness in his idea. Others will copy, then customers will not come to him. So he has to maintain his loyal followers because he is giving them something unique. So that is why there is need to protect intellectual property. And another is that it is capital expenditure for new products, because innovation or coming up with new idea or new design, it takes a lot of time. There is cost is involved in it, right? So it is basically, it is regarded as capital expenditure for new products. And one, for example, a company has research and development department, and they have given this job to the team that you have to come up something innovative for this particular line of products, right? And if they come up with it, they have invested in that R&D, research and development. So why would they want, if their R&D department has done that work, why would they want that others should reap their benefit? So that is why it is important to protect intellectual property. Then another important point is that it is marketing and advertisement. It is like, okay, I have got this new idea, I have got this new product innovation. I have this. Other companies do not have this. So to get a competitive edge, that only I own this, others do not own. So that is why it is important to protect this IPR. It is important to have intellectual property registered, protected. And no freeloaders. Why? Nobody else has worked on it. The creator has worked on it. Why he will give it to free to someone else, right? So that is why it is important to protect intellectual property. And it is an outcome of research and development. So it should remain with a particular creator or the company who has put money for sale. Now, talking about different types of intellectual property rights. So these are different types of property rights: patent, industrial designs, trademark, copyright, semiconductor integrated circuit layout registry, SIC LDR, geographical indications, plant variety and farmers' rights, and traditional knowledge. So these are different types of intellectual property rights. Now, what are patents? What is patent? Patent is, I hope all of you must be aware, patent is some new innovative idea, and this patent can be a new business model, idea of new business model, or a patent basically it can be a design, a new product design, a new design of some machinery or anything. So that is patent. When patent is anything related to product, patent is innovation related to product. So if we have some new design for a product, so we register it as a patent. Then there is another type of IPR is industrial design. So what is basically industrial design? Industrial design. What is basically industrial design? Industrial design is industrial design is basically designed specially for uh, those designs for industries, like for some plant, some machinery, some unique innovative design. So that comes under industrial design. Then trademark. Trademark, it is like it can be a unique symbol, logo. For example, you must have noticed that Nike, it has a tick sign, but its tick sign, that is also protected. It is also protected. So that is trademark. If any company uses a unique logo or unique symbol, right? So to make it stand uh, from others, so that is trademarks, because that trademark, it is sort of brand for that particular company. People come after that particular brand only, right? For example, I gave you example of this Nike, it has a tick mark. And for example, Gucci, it has its own trademark. iPhone has its own trademark. So their trademark also has value. So another type of intellectual property right, that is copyright. And copyright, it is applicable for books. It is applicable for written material, or books, or magazines, blogs, right? Even websites, they have copyright. Then semiconductor integrated circuit layout registry, that is for if someone comes up with some unique, innovative, new design for chips and all. So it comes under this. Then geographical indications, like if someone has, for example, found a new coal mine. He has found a new coal mine. He can go for intellectual property right for that geographical indications. Yes, I have found this coal mine, so it is mine. Okay, so the rights to mining, it belongs to me. And another is plant variety and farmers' rights. Plant variety, it means it is related to this botany. This for farmers. There's new, if some they come up with some new seeds, some new variety of seeds or anything. So that comes under their registering comes under plant variety and farmers' rights. Then there is traditional knowledge. A very good example of traditional knowledge is, for example, we have Ayurveda. Ayurveda is a traditional knowledge, and some of their, you can say, some of the medications of Ayurveda, they are registered, or they are also registered, they are also patented. So it is also regarded as intellectual property right. Now, if someone comes up with a startup and comes up with a new this intellectual property, yeah. So if someone comes with a new intellectual property, right? So as a startup, if someone is starting a new company, so in that startup or the entrepreneurs, what should they do? If a person is having some new idea, some innovative idea, and they want to start a this, they have want to have their own entrepreneurship venture with it. So first of all, if intellectual property is involved in it, what should they do? First of all, they should develop an intellectual property strategy. Strategy means how they are going to protect that particular intellectual property and how they are going to put it into use, whether they want to use it for their own business, whether they want to rent it, whether they want to sell it. Okay. And another next point is consider all forms of intellectual property. Then the person has to consider in which category of intellectual property this particular innovation comes. Then they have to conduct trademark availability and domain name clearance searches. If someone is coming up with some new innovative idea or some new trademark, anything, so they have to give name for that, right? They are coming up with some new intellectual property, they have to give name for that. So they, first of all, they must search if anyone else has given this particular name to their innovation or not. So they have to search availability for that innovation name. Then in this intellectual property, if you have to register for intellectual property or patent, it involves intellectual property attorneys, because they are going to take care of all the legalities, all the paperwork for registering your intellectual property. Okay. And it is and use NDA at very early stages of business. Non-disclosure agreement should be used at early stages of business. For example, if a creator is coming up with some new idea and they are making a lot of money out of it, so they should have non-disclosure agreement with all the people involved in the business at very early stage. For example, let me give you an example of KFC. All of you, yeah, KFC or McDonald's. So their products, that is, they have chains all over the world, right? But their recipes, they are patented, and whoever works with them, they have to sign a non-disclosure agreement related to the recipe, that they do not disclose the recipe or how this is done to others. So if intellectual property is involved, it is very important to have non-disclosure agreement in early stages of business. Okay, so these are the do's that need to be done. If there is some intellectual property involved and then there is some startup, first of all, develop an IP strategy, then consider all forms of IP, conduct trademark availability and domain name clearance searches, involve IP's attorneys, then use non-disclosure agreement at early stages of business. And what one should not do? Don'ts. First of all, skimp on your IP budget. Do not try to reduce your intellectual property budget. Okay, and file perfunctory provisional patent applications. Do not just delay your this application, patent application. First, you have to apply for provisional patent application. Do not delay it. Do it on time, and do it on time, and do not go for provisional patent application. Go for actual patent application. Okay, and uh, and do not focus your patent application on a specific technology only. Do not focus on specific technology. Make it more wider, more general. And whenever you're coming up with some new intellectual property, new innovation, new patent, do not ignore competitors' patents. What if you are thinking that you have made something new, but someone else already have done that? You are just getting happy for nothing. Someone else has already come up with that innovation. So do never ignore competitors' patents and never overlook the details. So now let's discuss these patents, because let's get to know it more. What is basically patent? So patent is basically an exclusive right granted for an invention, which is a product or a process. So it is exclusive right patent is exclusive right, because a person, a creator comes up with a product or a process or an invention, so that particular person is given that exclusive right to use it for commercial purpose, or any other purpose. So, and patent is usually granted for a period of 20 years. Patent is granted for a period of 20 years, and it is a territorial right. What do you mean by territorial right? Territorial right means that you have to file, if you are filing patent, you have to file patent in a particular country. So no one will be able to copy that. For example, if I come up with some new innovation and I file patent in, for example, Australian patent in Australia, so it means no one will be able to copy my idea in Australia. But I have not filed that patent in India. So, but in India, someone can copy it because I have not filed it in India. So it's a territorial right. It will be, your patent is applicable for that territory, for that country in which you have applied for patents. So nowadays you must have seen that the people, they have filed for patents. Some come with Indian patent, some even file for Australian patent. Some have started patent for African patent. So, but wherever you are this applying for patent, your this idea, innovation, that is protected in that particular territory. And another important point is that patent is granted on basis of novelty. What new you are coming up with, what new innovation you are doing. If there is something you are filing patent for something which is already there in the market, somebody else is already doing, then there is no novelty. Then their patent will not be this registered. And it has to be for some inventive step, something out of box, something new. And patent is applied, granted for those ideas which is capable of industrial application, for those ideas which can be used for commercial purposes, from which have economic value. And who can file a patent application? An inventor, the person who has invented it, an assignee, someone else on behalf of inventor, they can file a patent, and a legal representative of any deceased person, or a legal representative of a deceased person who had some idea. So where to file a patent application? If you have a patent application, where should you file it? A patent application should be an Indian resident can file for a patent at the head office of Indian Patent Office or its branches, depending upon the jurisdiction where he resides or has a domicile or has a principle of business. Okay, so they can file in India. And as I already told you, some Indians just for getting good score, API score, they are also doing patents for Australian patents and all. But if you want to protect your actual, you have really some good innovation, you should protect in your Indian jurisdiction. You should apply for Indian patent only. Okay, and in India you can apply it for in head office or its branches. It depends where you are located. So, and foreign nationals, they must have an address in India, then only they can apply for patent in India. And some of the patent offices in different regions, they are like for, for territories of state of Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, Union Territories of Daman and Diu, and Dadra and Nagar Haveli, patent offices in Mumbai. And for state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, National Capital Territory of Delhi, and Union Territory of Chandigarh, it is patent offices in Delhi. And for states of Andhra Pradesh, Kerala, Karnataka, Tamil Nadu, and Union Territories of Pondicherry and Lakshadweep, patent offices in Chennai. And for rest of India, those states which are not listed here, patent offices in, that's the head office, Kolkata. Now, there are different types of patent applications in India. One is ordinary application. Okay, ordinary application can be provisional application of complete application. Then there can be conventional application. Then there can be international application. then there can be national phase application, then there can be patent of addition. If you want, already there is some patent and you want to add something to it, that is patent of addition. Then there can be divisional application, it means patent applicable to a particular division only. And these are the important documents required for filing a patent application. You need to have a covering letter indicating the list of the documents, all the documents that you are going to file. Then there is application form 1, that is available with the website of patents and available in office also. Then there is provisional or complete specification and duplicate, that is form 2. And if the provisional specification is filled, it must be followed by complete specification within 12 months. If a person is filing for provisional specification, then they have to file for complete specification within 1 year. And then drawing of the patent, right? That is also important. That has to be filed. That has to be filed while filing a patent application, and abstract of the invention. Abstract of the invention, like the summary of the invention, like what is the design, how it works, how it can be useful, right? All the material required for it, all the specifications, they are in abstract of the invention. In summary, it has to be explained. And other documents are information in the undertaking, information and undertaking listing the number, filing date, and current status of each foreign patent application, form 3. Okay, so it has information and undertaking which has the number, filing date, and current status. It is for foreign patent application. All right. Then there is another this document, that is certified true copy of the priority document in case priority is claimed. If any person, they are in hurry, they want that their patent should be registered first. They are in hurry, or they should file for a priority patent. So for that, they should have a true copy of priority document. And declaration of inventorship. Okay, declaration of inventorship is for conventional application. It is in form 5. Then power of attorney. If inventor himself is not filing for the patent, he's doing it through agent, then power of attorney is required. And requisite statutory fee. So fee for applying for patent, that is also necessary. It can be online payment or check or demand draft. So these are some of the forms for filing a patent. Form number 1. These are the mandatory forms. Form number 1 for application for grant of patent. Form number 2 for provisional or complete specification, and it has to be filled within 12 months of filling the provisional specification. Then form number 3, it is for statement and undertaking for foreign application, and it has to be filled within 6 months from the date of filling of application. Then we have declaration of inventorship. It has to be filled with complete specification or within 1 month from the date of filling of the complete specification. That form 18, it is request for examination. Then form 18A, request for expedited examination. And this form has to be filled within 48 months from the date of filling or priority, whichever is earlier. Then form 26, it is for authorization of a patent agent or any person in a matter of proceeding. These are mandatory forms. And optional form is, as I already told you, if someone is in a hurry, they want early publication, they can fill form number 9. That is request for early publication. That is request for early publication. So here, see, this is patent process and the timeline involved. As you can see, first you can apply for patent. They can be either you can go for provisional application on the left hand side. The right hand side you can see complete specification. Let's take first two, provisional application. If you're going ahead with provisional application, then there is within 12 months you have to file for complete specification, right? And if you do not file for complete specification, then it is deemed to be withdrawn, right? So let's go with now. When you apply for complete specification, after 18 months, you have publication of application, and within 48 months, you have to request for examination. And if request for examination is filled, then first examination report is issued, okay, and it can be extended by 6 months, okay. And if there is a response to first examination report is hearing, then order for grant, it can be hearing, order for grant, and hearing has to be within 15 days, where there is reply for objections in hearing, or it can be order for grant. It means publication of grant patent number allotted, and response to first examination report ki order for refusal. So then after order for refusal, within 3 months, the inventor can appeal against the order. Within 3 months, they have to appeal against this order. And if there is no response to first examination report, so it means it is deemed, if there is no response to first examination report, it is deemed to be withdrawn. And even if no request for examination is filed, it is deemed to be withdrawn. So this is patent process and different timelines for same. So then we have technology transfer. So this was about patent, how we can file patent. We are coming up with some innovative idea. So another, I'm just giving you briefing about technology transfer also, because technology transfer, that is also very important. So technology transfer, it can be defined as movement or flow of technical knowledge, design, prototype, data know-how, trade materials, invention, software from one party to another party capable of commercialization, and technology readiness levels are used as a measurement of the maturity level of particular technique. So what happens in technology transfer means any type of technology, and technology, it can be related to design, it can be related to prototype, it can be related to this data, it can be related to any it can be related to any invention. Okay, so transfer of that technology, uh, and technology transfer, it comes under TRL 9 if there is actual system flight proven through successful mission operations. TRL technology transfer, technology readiness. These are TRL are technology readiness levels. So basically, these technology readiness levels, they are these levels tell us the maturity level of a particular technology. So these technology readiness levels tell us this levels of different maturity level. So let's start with TRL 1, TR technology readiness level 1. It is about basic principles observed and reported. TRL 2 is technology concept and or application formulated. TRL 3 is about analytical and experimental critical function and or characteristic proof of concept. TRL 4 is about component and or breadboard validation in laboratory environment. Then TRL 5 is about component and or breadboard validation in relevant environment. TRL 6 is about system or subsystem model or prototype demonstration in a relevant environment, ground space. TRL 7 is system prototype demonstration in a space. And see, as we move up, the technology is also moving up. We are going with high technology. TRL 1 is basic one. So see, we are now into talking about space technology and all. Then TRL 8 is about actual system completed and flight qualified through test and demonstration, ground or space. TRL 9 actual system flight prone through successful mission operations. So these are different levels, technology readiness levels, when we are talking about technology transfers. So who are the main key players in technology transfers? Technology, coming up with new technology, it is not work of a single person sitting at home and doing some invention. It involves proper research and development, because it needs a lot of infrastructure also, a lot of high end computers or simulation and all. So it is key players of technology transfer, research and development or academic institutions. They are the key players of technology transfer. They can be companies, which can be private or MSMEs or startups, or they can be different funders. Different funders, because they believe in that technology, they give funding to the inventor for going ahead with this. Or they can be technology transfer offices. So basically, these technology transfer offices, these are transmission channel between the research and the market environments. So this is basically technology transfer process. First, we have research, then pre-submission and invention submission. It comes under submitting a technology disclosure. Then there is assessment, protection, marketing to find to formal license. It comes under patenting and invention. Then there is existing business or from startup business, licensing, commercializing, revenue, reinvest in research and education. It comes under commercializing and invention. So it starts with submitting a technology disclosure steps, then patenting and invention, and commercializing and invention. So these are the different steps involved in technology transfer process. And now commercialization of intellectual property. What is basically commercialization of intellectual property? Commercialization of intellectual property is defined as the process of bringing intellectual property to the market in view of future profits and business growth. And so it means using that intellectual property, that innovative idea or design for some business to earn profits. That is commercialization. So here, if a startup or small or medium industry, some new entrepreneurs or some existing small companies, they want to commercialize their IP. So what all they have to do? First, they have to uh, IP commercialization. How they can do? First, it can be done by the IP owner, intellectual property owner, or IP commercialization can be done through assignment, and it can be done through business partnerships. Partnerships, it means the creator comes into partnership with some other person. They can start the business partnership. It can involve licensing and franchising, or joint venture and spin-offs, or IP elements in other business contracts. So this is about commercialization of IP. So this is I have tried my best to give you some idea about this intellectual property rights, and how we can use it, and how we can go ahead with applying for intellectual property. Thank you so much.
Thank you, ma'am. Thank you very much. I would like to take up some questions from the participants. Any of the faculties present? Okay. Maybe there are no questions. Ma'am, I would like to ask you something, ma'am. What is the cost that we incur for filing a patent in India or in any other countries? How much may be the cost? Not actually, but
So it is actually not cost, it is the fee.
okay.
It is not, it is fee. As I told you, that actual fee is related to IP attorney. As I already told you, that IP attorney has to be, we need to have an IP attorney for filing a patent, right? So some chunk of the money goes to IP attorney, and some goes as a fee.
Okay.
That is why you must have observed, if you have filed for a patent, then a person alone, it becomes difficult. Like there are almost 50, 60,000. That much amount is minimum that is involved. So that is why in academics, what we do, we just few people do these. We collaborate in case of patents, because at one time it is not possible to give fee. So at least 50, 60,000 is involved, and the main cost is with IP attorney, and fee with the patent office.
Okay, ma'am. Another question, ma'am, I have actually. What is the, ma'am, actual difference that between the applicant and the inventors during filing or in the patent files? I have seen that there are different applicants and different inventors. What does that mean?
See,
Yeah, ma'am.
inventor is the person
Mhm.
who has the invent. You have in applicant is basically regarded as the main inventor. If
Okay.
we we collaborate for different patents.
Okay, ma'am.
So inventors, you can see there are a lot of inventors, right? So, but the main inventor is regarded as the one who is applicant.
Okay, okay, ma'am.
He gets more weightage.
Okay, ma'am. Actually, I've seen that in some patents, the institute names are given as only applicants, and mainly the faculties or any other students doing the research are given as inventors. So that's why I just asked you, ma'am. I had that question.
Okay.
Any of the participants having any questions? Okay, ma'am. I think there are no more questions from the participants' end. So,
Thank you
with
so
this, I would like to conclude the session. Thank you, ma'am. Thank you very much for giving us your time and sharing the need of IPR or patent filing for academics. And for the first, you only have discussed about how much it is important for the faculties to do the patent and how much weightage it is for us for our career, and for the students how much they can be involved in the invention and all other things. So again, ma'am, from Sri Ramakrishna Institute of Science and Technology, I thank you very much for your time and your sharing the knowledge, ma'am.
Thank you so much for giving me this opportunity. Thank you.
Thank you, ma'am. Thank you. Okay, participants, we are concluding the session over here. Tomorrow at same time we will be having the session on digital entrepreneurship. So let us meet tomorrow at 6 p.m. with the same link. Thank you all. But where I would like to add some points to the participants, that as these speakers are very much invited from other institutes and having good reputation in the field of academics, when we are inviting them, they would also like to communicate with you all. It is request from all of us from IIC team that please communicate with the speakers so that the session becomes interactive. Otherwise, it is of no use that just for listening or coming on with the being live is not the only solution. Yesterday also, it has been noticed that none of you have asked any question, and today also there were no questions. I would also like all of you to come forward and ask questions, clear your doubts, because these things are going to help you for your career development and career orientation in the right path. Okay. So, thank you all. Thank you again, and see you tomorrow, all of you. Thank you.